Power Knowledge, Selected Interviews and Other Writings, 1972 to 77. Michel Foucault, edited by Colin Gordon. Translated by Colin Gordon, Leo Marshall, John Metham, Kate Sober. This collection copyright 1980 by the Harvester Press. Preface. Michel Foucault's name, at least, must now be a familiar one to English-speaking readers, since this is the 10th volume of his writings to have been translated within the last dozen years. But perhaps the distinctive features of his work have not always been easy for us to discern from among that gyrating nebula of Gallic luminaries which we have been so arduously and querulously observing during the span of Foucault's career to date. One of the motives for fabricating and translation this further Foucault book has therefore been the hope that it will facilitate access to works that are, at least in principle, already available, to construct a sort of non-didactic primer made up of text in which the author himself explains in straightforward and informal terms some stages and facets of his work and the preoccupations that traverse it. By bringing into clearer focus the political and intellectual environment in which this work has been carried out, this volume should help to undo some of the obfuscating effects commonly produced by the use of such vague and polemical labels as structuralism and post-Marxism, and hence make possible a more informed estimate of its significance within contemporary thought, or, to speak less grandly, of the interest, utility, and pleasure it offers us. A few words about the material selected. All the pieces date from since Foucault's election following a brief spell as one of the founders of the experimental University of Vincennes to the chair of History of Systems of Thought at the Collège de France. Within his published output, they succeed his two methodological and programmatic texts, The Archaeology of Knowledge, 1969, and The Order of Discourse, 1970. With the exception of Chapter 1, which is a discussion occasioned by an episode in post-1968 revolutionary French politics, all of the book is closely linked to the themes and arguments of Foucault's two most recent works, Discipline and Punish, 1975, and The Will to Know, History of Sexuality 1, 1976. We have sought to minimize internal redundancies and have omitted items already widely available in English. The resulting pattern is that of an aleatory, open-ended collage in which from point to point and in changing contexts and perspectives, a certain number of figures and motifs recur. The forms and occasions of the pieces, the identity of the interlocutors, and the origin and points of the questions posed are numerous and diverse. Some texts are more or less direct oral transcripts, others are writings in a more orthodox sense. Some have never appeared in France or are no longer available there. The diversity of this volume's sources, documented in a separate note below, gives an indication of the remarkable impact of Foucault's books in France and elsewhere, an impact by no means confined to the literary beau monde. What are in essence historical essays, albeit unconventional ones in their scope and form, have encountered a wide and receptive audience among the proliferating intellectual and militant action groups, campaigns, currents, and publications which have been a feature of the international terrain since the 1960s. One should note that this volume does not represent Foucault's important and extensive journalistic output on topics including capital punishment, abortion, suicide, prison revolts, and the recurring scandals of justice and psychiatry, not to speak of their everyday norms, crime and punishment in the Soviet Union, China and Iran, and the popular uprising in the latter country. Some of his articles, notably those on the application of the guillotine by Presidents Pompidou and Giscard, have a philippic force rare in contemporary writing. What is striking about the discussions collected here is the way in which the dimensions of history and philosophy are brought to intersect and interact with the same detailed confrontation of present actuality. It would nevertheless be misplaced to set about installing Foucault within the lineage of Voltaire, Zola, and Sartre, French tradition of great intellectual paladins of justice and truth. For reasons which his analysis of the twilight of the universal intellectual, see page 126 and forward, makes clear, Foucault has persistently and dexterously avoided the canonical roles of revolutionary guru, great and good writer, or master thinker. This feature of his personal trajectory, while making it less readily visible from afar than those of other illustrious contemporaries and predecessors, may perhaps turn out to be as seminal as any system of theoretical positions to be extracted from his books. At any rate, part of the interest of the present volume lies in the complex relationship it documents between a singular intellectual venture and some common issues posed by our recent historical experiences. Collaborative, consciously provisional, often fragmentary and digressive, abounding in hypotheses and sparing in conclusions, these dialogues manifest their own kind of rigor through an abiding concern constant throughout Foucault's work to question and understand the fluctuating possibilities, the necessary or contingent historical limits of intellectual discourse itself. The problematic of pouvoir savoir, power and knowledge, which has given this book its title, is a fundamental theme of Foucault's historical studies of the genealogy of the human sciences. It is also, ineluctably, a fundamental question concerning our present. This also means that these discussions, given their location in time and space, have to do with the events of May 1968 and the transformations of political thought and practice which these events were seen as inaugurating. Now, some years later, one can tentatively identify the years around 1972 to 77. Now, some years later, one can tentatively identify the years around 1972 to 77 in France as an unusual and fascinating, albeit confused period, during which new lines of investigation and critique emerged on the intellectual scene in a relationship of mutual stimulation with new modes of political struggle conducted at a multiplicity of distinct sites within society. This is not, of course, to say that France has been unique in this respect, nor that the relationship in question should be understood as having provided these new zones of militancy with a set of perfect and reciprocal political and theoretical legitimations. In France, moreover, many would now see this period of intellectual ebullition and pervasive local struggles as over, ended at the latest by the electoral debacle of 1978. But if these years' climate of immediate optimism has for the moment given way, and not only in France, to one of morosité, something of their vitality will, we hope, be transmitted through the present texts. The chapters in this book are arranged in approximate chronological order. Readers new to Foucault may, however, prefer to start with chapters 5 and 6 for a general overview, and chapters 2 and 10 for presentations of the recent books. Foucault is his own best expositor, and his writings are intractable material for the commentator's arts. I have, however, added as an appendix an essay in which I attempt a speculative summary of the philosophical background to Foucault's enterprise and its main conceptual architecture. Colin Gordon. 1. On Popular Justice, a discussion with Maoists. In the following discussion, Michel Foucault and some Maoist militants attempt to identify the basic issues in a debate which had been initiated in response to the project of June 1971 to set up a people's court to judge the police. Foucault. In my view, one shouldn't start with a court as a particular form and then go on to ask how and on what conditions there could be a people's court. One should start with popular justice, with acts of justice by the people, and go on to ask what place a court could have within this. We must ask whether such acts of popular justice can or cannot be organized in the form of a court. Now, my hypothesis is not so much that the court is the natural expression of popular justice, but rather that its historical function is to ensnare it, to control it and to strangle it, by reinscribing it within institutions which are typical of a state apparatus. For example, in 1792, when war with neighboring countries broke out and the Parisian workers were called on to go and get themselves killed, they replied, "We're not going to go before we've brought our enemies within our own country to court. While we will be out there exposed to danger, they'll be protected by the prisons they're locked up in." The They're only waiting for us to leave in order to come out and set up the old order of things all over again. In any case, those who are in power today want to use against us, in order to bring us back under control, the dual pressure of enemies invading from abroad and those who threaten us at home. We're not going to fight against the former without having first dealt with the latter. The September executions were at one and the same time an act of war against internal enemies, a political act against the manipulations of those in power, and an act of vengeance against the oppressive classes. Was this not, during a period of violent revolutionary struggle, at least an approximation to an act of popular justice, a response to oppression, strategically effective and politically necessary? Now, no sooner had the execution started in September, when men from the Paris Commune, or from that quarter, intervened and set about staging a court. Judges behind a table, representing a third party, standing between the people who were screaming for vengeance, and the accused who were either guilty or innocent. An investigation to establish the truth, or to obtain a confession. Deliberation in order to find out what was just. This form was imposed in an authoritarian manner. Can we not see the embryonic, albeit fragile, form of a state apparatus reappearing here? The possibility of class oppression is not the setting up of a neutral institution standing between the people and its enemies, capable of establishing the dividing line between the true and the false, the guilty and the innocent, the just and the unjust? Is this not a way of resisting popular justice? A way of disarming it in the struggle it is conducting in reality in favor of an arbitration in the realm of the ideal. This is why I am wondering whether the court is not a form of popular justice, but rather its first deformation. Victor: Yes, but look at examples taken not from the bourgeois revolution, but from a proletarian revolution. Take China. The first stage is the ideological revolutionization of the masses, uprisings in the villages, acts of justice by the peasant masses against their enemies, executions of despots, all sorts of reprisals for all the extortion suffered over the centuries, etc. The executions of the enemies of the people spread, and we would all agree in saying that these were acts of popular justice. All this is fine. The peasant has a good eye for what needs to be done, and everything goes just fine in the countryside. But a new stage in the process develops, with the formation of a Red Army, and then it is no longer simply a matter of the masses in revolt against their enemies, for now we have the masses, their enemies, plus an instrument for the unification of the masses, namely the Red Army. At this point, all of the acts of popular justice are supported and disciplined, and it is necessary that there be some legal authority so that the diverse acts of vengeance should be in conformity with law, with a people's law, which is now something entirely different from the old system of feudal law. It has to be decided that this particular execution or that particular act of vengeance is not simply a matter of an individual settling of accounts, that is purely and simply an egotistical revenge against all the oppressive institutions which had themselves equally been based on egoism. In this case, it is true that there is what you call a neutral institution which stands between the masses and their immediate oppressors. Would you argue that at this point in the process, a people's court is not only a form of popular justice, but is a deformation of people's justice? Foucault: Are you certain that in this example a neutral institution came to intervene between the masses and their repressors? I do not think so. I would say that, on the contrary, it was the masses themselves which came to act as intermediary between any individual who might become separated from the masses, from the aims of the masses, in order to satisfy an individual desire for vengeance, and some other individual who might well, in fact, be an enemy of the people, but whom the former individual might be aiming to get at simply as a personal enemy. In the example which I was discussing, the People's Court, as it functioned during the Revolution, did tend to act as a neutral institution, and moreover it had a very precise social basis. It represented a social group which stood between the bourgeoisie in power and the common people of Paris, la plebe. This was a petty bourgeoisie composed of small property owners, tradesmen, artisans. This group took up a position as intermediary and organized a court which functioned as a mediator. In doing this, it drew on an ideology which was up to a certain point the ideology of the dominant class, which determined what it was right or not right to do or to be. This is why, in this court, they convicted not only refractory priests or people involved in the events of 10 August, quite a small number of people, but they also executed convicts, that is, people who had been convicted by the courts of the Ancien Regime. They executed prostitutes, and so on. So it is clear that it had reoccupied the median position of the judicial institution just as it had functioned under the Ancien Regime, where there had originally been the masses exacting retribution against those who were their enemies. There was now substituted the operation of a court and of a great deal of its ideology. Victor. This is why it is interesting to compare cases of courts during the bourgeois revolution with cases of courts during the proletarian revolution. What you have described comes down to this. Between the masses at the base, what then constituted the people on the one hand and their enemies on the other, there was a class. The petty bourgeoisie, a third party, which was an intermediary, which took something from the common people and something else from the class which was becoming dominant. It thereby played the role of a median class. It coalesced these two elements, and this gave to the People's Court what was, from the point of view of the development of popular justice which was being conducted by the common people, an element of internal repression, thus a deformation of popular justice. So if there is a third party, this does not arise from the court itself, it comes from the class which took over the courts, that is, from the petty bourgeoisie. Foucault. I would like to take a brief look backwards at the history of the state judicial apparatus. In the Middle Ages there was a change from the court of arbitration to which cases of dispute were taken by mutual consent, to conclude some dispute or some private battle, and which was in no way a permanent repository of power, to a set of stable, well-defined institutions which had the authority to intervene and which were based on political power, or at any rate were under its control. This change was accomplished in conjunction with two underlying processes. The first was the fiscalization of the judicial system. By means of fines, confiscations, distraints, by granting expenses and all sorts of allowances, operating the judicial system became profitable. After the breakdown of the Carolingian state, the judicial system became, in the hands of the nobles, not only an instrument of appropriation, a means of coercion, but a direct source of revenue. It produced an income over and above feudal rent, or rather it became an aspect of feudal rent. To be a judge was to have a source of income. It was property. Judgeships became a form of wealth, which could be exchanged, circulated, which were sold or inherited as part of or sometimes separately from fiefs. They became an integral part of the circulation of wealth and of the feudal levy. For those who owned them, they constituted rights, in addition to those of quit rent, mortmain, tithe, tonnage, banalité, etc. And for those who came under their jurisdiction, they amounted to a kind of taxation which was not systematized, but to which it was nevertheless in certain cases certainly necessary to submit. The archaic operation of the judicial system had become inverted. One could say that in earlier times justice was a right for those to whom it was applied, the right to demand justice when the disputants agreed to do so, and a duty for those who made the judgments, the obligation to exercise their prestige, their authority, their wisdom, their politico-religious power. It was to become from this point on a lucrative right for those in power, and a costly obligation for those who had to submit to it. At this point we can see the convergence with the second of the processes which I mentioned earlier, the increasing link between the judicial system and armed force. To replace private wars by a compulsory and lucrative judicial system, to impose a judicial system where one is at one and the same time judge, party to the dispute, and tax collector, instead of a system of deals and settlements, to impose a judicial system which secures, guarantees, and increases by significant amounts the levy on the product of labor, all this implies the availability of the power of constraint. It could not be imposed without armed force. Wherever a feudal lord disposed of sufficient military power to enforce his peace, it was possible for him to impose juridical and fiscal levies. Having become a source of income, judgeships developed in the direction of the division of private property, but supported by the force of arms, they developed in the direction of its ever-increasing concentration. This dual development led to the classical result, when during the 14th century the feudal lords were faced with the great peasants and urban revolts. They sought the support of a centralized power, army and taxation system, and in this emergency there arose, together with the provincial high courts, the king's procurators, official prosecutions, legislation against beggars, vagabonds, idlers, and before long the early rudimentary forms of police and a centralized judicial system. This was an embryonic state judicial apparatus which was superimposed upon, duplicated, and controlled the feudal judges and their fiscal rights, but which allowed them to continue to function. There thus sprang up a judicial order which had the appearance of the expression of public power, an arbitrator both neutral and with authority, of whom the task was both to justly resolve disputes and to exercise authority in the maintenance of public order. It was on these foundations of social struggles, the levying of taxes, and the concentration of armed force, that the judicial apparatus was erected. We can understand, then, why it is that in France and, I believe, in Western Europe, the act of popular justice is profoundly anti-judicial, and is contrary to the very form of the court. In all the great uprisings since the 14th century, the judicial officials have regularly been attacked, on the same grounds as have tax officials, and more generally those who exercise power. The prisons have been opened, the judges thrown out, and the courts closed down. Popular justice recognizes in the judicial system a state apparatus, representative of public authority, an instrument of class power. I would like to put forward a hypothesis, though I am not certain about it. It seems to me that a certain number of habits which derive from the private war, a certain number of ancient rights, which were features of prejudicial justice, have been preserved in the practices of popular justice. For example, it was an old Germanic custom to put the head of an enemy on a stake for public viewing when he had been killed according to the rules, or juridically, in the course of a private war. The destruction of the house, or at least the burning of the timber work, and the ransacking of the contents of the house is an ancient rite which went together with being outlawed. Now, these are acts which predate the setting up of a judicial system, and which are regularly revived in popular uprisings. The head of Delany was paraded around the captured Bastille. Around the symbol of the repressive apparatus revolves, with its ancient ancestral rights, a popular practice which does not identify itself in any way with judicial institutions. In my view, the history of the judicial system as state apparatus enables us to understand why, in France at least, acts of justice which really are popular tend to flee from the court, and why, on the other hand, each time that the bourgeoisie has wished to subject a popular uprising to the constraint of a state apparatus, a court has been set up, a table, a chairman, magistrates confronting the two opponents. Thereby the judicial system is reborn. That is my view of things. Victor: Yes, you see things up to 1789, but what I'm interested in is what happens later. You have described the birth of a class idea, and how this class idea was materialized in practices and apparatuses. I perfectly well understand how it was possible in the French Revolution for courts to become instruments of indirect deformation and repression of the acts of popular justice of the common people. If I've understood, this was because there were several social classes involved. On the one hand, the common people, on the other hand, the traitors to the nation and to the revolution, and between them a class which attempted to play out to the full the historical role which was open to it. Therefore, I cannot draw any definitive conclusions about the form of the people's court from this example. In any case, for us there are no forms which are incapable of historical development, but merely see how the petty bourgeoisie as a class picked up from the common people some scrap of an idea and then, being dominated as it was, especially in this period, by the ideas of the bourgeoisie, crushed the ideas drawn from the common people under the form taken by courts at that time. I cannot draw from this any conclusions about the practical problem we are faced with today concerning people's courts in the present day ideological revolution, nor, a fortiori, in the future people's armed revolution. This is why I would like us to compare this example from the French Revolution with the example which I mentioned just now, that of the people's armed revolution in China. Now you would say, in this example there are only two elements, the masses and their enemies, but the masses in a way delegate some part of their power to an element which, while being deeply attached to them, is nevertheless distinct, the people's Red Army. Now this figure, military power, judicial power, which you pointed out, can be seen again here with the people's army helping the masses to organize regulations covering the trial of class enemies. I myself do not find anything surprising about this, given that the people's army is a state apparatus. So I would put the following question to you. Are you not dreaming up the possibility of going straight from present-day oppression to communism without any transition period, that which is traditionally called the dictatorship of the proletariat, during which there is a need for a new type of state apparatus of which we must define the content? Is it not this which lies behind your systematic refusal of the people's court as a form? Foucault. Are you certain that it is merely the form of the court that is involved here? I do not know how these things are done in China, but look a bit more closely at the meaning of the spatial arrangement of the court, the arrangement of the people who are part of or before a court. The very least that can be said is that this implies an ideology. What is this arrangement? A table, and behind this table, which distances them from the two litigants, the third party, that is, the judges. Their position indicates firstly that they are neutral with respect to each litigant, and secondly this implies that their decision is not already arrived at in advance, that it will be made after an oral investigation of the two parties on the basis of a certain conception of truth and a certain number of ideas concerning what is just and unjust, and thirdly that they have the authority to enforce their decision. This is ultimately the meaning of this simple arrangement. Now this idea that there can be people who are neutral in relation to the two parties, that they can make judgments about them on the basis of ideas of justice which have absolute validity, and that their decisions must be acted upon, I believe that all this is far removed and quite foreign to the very idea of popular justice. In the case of popular justice, you do not have three elements. You have the masses and their enemies. Furthermore, the masses, when they perceive somebody to be an enemy, when they decide to punish this enemy or to re-educate him, do not rely on an abstract universal idea of justice. They rely on their own experience, that of the injuries they have suffered, that of the way in which they have been wronged, in which they have been oppressed, and finally, their decision is not an authoritative one. That is, they are not backed up by a state apparatus which has the power to enforce their decisions. They purely and simply carry them out. Therefore, I hold firmly to the view that the organization of courts, at least in the West, is necessarily alien to the practice of popular justice. Victor. I do not agree. Or as you discuss concretely all revolutions up to the proletarian revolution, you become completely abstract when talking about modern revolutions, including those that have occurred in the West. That's why I'll now take a new case, coming back to France. During the Liberation, there were a variety of acts of popular justice. I will deliberately take an ambiguous example of popular justice, an act of popular justice which was both real yet ambiguous, that is, an act which was in effect manipulated by the class enemy. We can draw a general conclusion from this so as to locate more exactly the theoretical criticism which I am making. I want to discuss those young women whose heads were shaved because they had slept with the Germans. In one way, this was an act of popular justice, for intercourse in the most physical sense of the term with Germans was something which was offensive to the deepest bodily sense of patriotic feeling. This really was an emotional and physical injury to the people. However, it was an ambiguous act of popular justice. Why? Quite simply because while the people were being entertained by shaving the heads of these women, the real collaborators, the real traitors, remained untouched. So the enemy was allowed to exploit these acts of popular justice. Not the old enemy, the Nazi occupation forces, now disintegrating militarily, but the new enemy, the French bourgeoisie, with the exception of a small minority who were too compromised by the occupation and who could not come out into the open too much. What can we learn from this ambiguous act of popular justice? Not at all the conclusion that this mass movement was unreasonable, because there was in fact a reason for this act of retaliation against young women who had slept with the German officers, but that if the mass movement is not given proletarian unity and direction, it can disintegrate from within and be exploited by the class enemy. In short, the mass movement on its own is not enough. This is because there are contradictions among the masses. These contradictions within a popular movement can easily cause its development to take a wrong course, to the extent that the enemy takes advantage of them. So it is necessary for there to be an organization to regulate the course of popular justice, to give it direction. And this cannot be done directly by the masses themselves, precisely because what is needed is an organization which is able to resolve the masses' internal contradictions. In the case of the Chinese Revolution, the organization which enabled these contradictions to be resolved, and which played the same role once again after state power had been seized at the time of the Cultural Revolution, was the Red Army. Now, the Red Army is different from the people, even though it is linked to them, even though the people love the army and the army loves the people. Not all Chinese were in the Red Army, and they are still not so today. The Red Army represents a delegation of the power of the people. It is not the people themselves. This is also why there is always the possibility of a contradiction between the army and the people, and there will always be the possibility that the state apparatus will repress the popular masses, and this opens up the possibility and the necessity for a whole series of cultural revolutions, precisely in order to abolish contradictions which have become antagonistic between the state apparatuses, such as the army, the party, or the administrative apparatus, and the popular masses. Therefore, I would be against people's courts. I would find them completely unnecessary or detrimental if the masses, once set in movement, were a homogeneous whole. That is, in short, if there were no need, in order to keep the revolution moving ahead, for institutions which could discipline, centralize, and unify the masses. In other words, I would be against people's courts if I did not think that to make the revolution it is necessary to have a party, and for the revolution to keep going, a revolutionary state apparatus. As for the objection which you put forward on the basis of the analysis of the spatial arrangement of courts, my reply is as follows. On the one hand, we are not forced to adopt any particular form, in the formal sense of spatial arrangement, for any particular court. One of the best of the liberation courts was that at Bethune. Hundreds of miners had decided to execute a Boche, that is, a collaborator, and they left him in the central square for 7 days. Each day they turned up and they said, "We'll execute him," and then went away again. The lad was still there and they still didn't execute him. At that point, somebody marginal, I'm not sure who exactly, with some vestige of authority left, said, "Let's get it over with, lads. Either kill him or let him go. We can't go on like this." And they said, "Okay. Come on, comrades, we'll execute him." And they took aim and fired, and before dying, the collaborator cried out, "Heil Hitler," which allowed everyone to say that the decision had been a just one. In this example, there was not the spatial arrangement that you describe. What forms should the judicial system take under the dictatorship of the proletariat? This is an unanswered question, even in China. Things are still at an experimental stage on this question, and there is a class struggle around the question of the judiciary. You can see from this that it is not a matter of once again adopting the table, the magistrates, etc., but here I'm only touching on the superficial aspect of the problem. Your example went much further. It pointed to the problem of neutrality. As far as popular justice goes, what happens to this necessarily neutral third element, which is purportedly in possession of a truth different from that of the popular masses, and by virtue of this acting as a shield? Foucault. I identified three elements. 1. A third element. 2. Reference to an idea, a form, a universal rule of justice. 3. Decisions with power of enforcement. It is these three characteristics of the courts which are represented in anecdotal fashion by the table in our society. Victor. The third element in the case of popular justice is a revolutionary state apparatus, for example, the Red Army in the early stages of the Chinese Revolution. In what sense is it a third element, a repository of a law and of a truth? This is what needs to be explained. There are the masses, there is this revolutionary state apparatus, and there is the enemy. The masses express their grievances and compile an inventory of all the extortions, of all the suffering caused by the enemy. The revolutionary state apparatus takes note of this inventory, and the enemy interjects, "I don't agree about such and such a point." Now, the truth as far as the facts are concerned can be established. If the enemy has betrayed 3 patriots, and if the whole population of the commune is present and are agreed on a verdict, then it must be possible to establish the facts of the matter. If it is not, then there must be some problem. If there is no agreement that he is guilty of such and such an extortion, then the least that can be said is that the desire to execute him is not an act of popular justice, but a settling of accounts between some minority fraction of the masses with egotistical ideas and this enemy, or this alleged enemy. The facts of the matter have been established. The role of the revolutionary state apparatus is not yet over. Already, during the investigation of the facts, it has played a role, since it has allowed the whole of the actively participating population to list the charges against the enemy. But its role does not stop here. It still has a contribution to make when it comes to deciding on the sentence. Say the enemy is the owner of some moderately large factory. The fact can be established that he really did exploit the workers abominably, that he was responsible for quite a few accidents at work. Is he to be executed? Let us suppose that it is desirable that the middle bourgeoisie be rallied to the cause of the revolution, that it is said that only the very small handful of arch criminals should be executed, and that these can be identified by objective criteria. Then this enemy would not be executed, even though the factory workers whose friends had been killed have a violent hatred of their boss and would perhaps like to execute him. This could constitute a perfectly correct policy, as was, for example, during the Chinese Revolution, the deliberate minimizing of the contradictions between the workers and the national bourgeoisie. I don't know if it would happen like that here, but I will give you a hypothetical example. It is probable that not all the bosses would be liquidated, particularly in a country like France where there is a large number of small and medium-sized firms, so that this would amount to too many people. All this comes down to saying that the revolutionary state apparatus, representing the general interest which have priority over those of any particular factory or any particular village, applies objective criteria in sentencing. I'll go back again to the example of the early stages of the Chinese Revolution. At a certain point in time it was correct to attack all landowners, while at other points there were some landowners who were patriots and who had to be spared. It was necessary to educate the peasants and so to go against their natural inclinations with regard to these landowners. Foucault. The procedures you have described seem to me completely alien to the very form of the court. What role is played by this revolutionary state apparatus, in this case the Chinese army? Is its role to choose between two sides for one rather than the other, between the masses who represent one particular will or one particular interest and an individual representing a different interest or will? Obviously not, because it is a state apparatus which is engendered by the masses, which is under the control of the masses, and which will carry on being controlled by them, and which in fact has a positive role to play, not in making decisions as between the masses and their enemies, but in guaranteeing the education, the political training, the broadening of the political vision and experience of the masses. So is the job of the state apparatus here to determine sentences? Not at all, but to educate the masses and the will of the masses in such a way that it is the masses themselves who come to say, in fact, we cannot kill this man, or in fact, we must kill him. You can see clearly that this is not at all the way that courts operate as they exist at the present time in France, where they are of an entirely different order, in which it is not one of the parties which is in control of the judicial system, and where the judicial system has no educative role to play. To go back to your earlier example, if people went rushing after women to shave their heads, it was because the collaborators who should have been their natural targets and against whom they should have exercised popular justice were presented to the masses as being too difficult to deal with in that way. It was said, "Oh, those people's crimes are too great. We'll bring them before a court." They were put in prison and were brought before the courts, and they, of course, acquitted them. In this case, the courts were just used as an excuse for dealing with things other than by acts of popular justice. Now I've arrived at the basic point of my thesis. You speak about contradictions among the masses, and you say that there is a need for a revolutionary state apparatus to help the masses resolve these contradictions. Now, I don't know what happened in China. Perhaps the judicial apparatus was like those in feudal states, an extremely flexible apparatus with little centralization, etc. In societies such as our own, on the contrary, the judicial apparatus has been an extremely important state apparatus on which the history has always been obscured. And people do the history of law and the history of the economy, but the history of the judicial system, of judicial practices, of what has in fact been a penal system, of what have been systems of repression, this is rarely discussed. Now, I believe that the judicial system as a state apparatus has historically been of absolutely fundamental importance. The penal system has had the function of introducing a certain number of contradictions among the masses, and one major contradiction, namely the following: to create mutual antagonism between the proletarianized common people and the non-proletarianized common people. There was a particular period when the penal system, of which the function in the Middle Ages had been essentially a fiscal one, became organized around the struggle to stamp out rebellion. Up until this point, the job of putting down popular uprisings had been primarily a military one. From now on, it was to become taken on or rendered unnecessary by a complex system of courts, police, prison. It is a system which has basically a triple role, and depending on the period, depending on the state of struggles and on the conjuncture, it was one or the other of these roles which was dominant. On the one hand, it is a factor in proletarianization. Its role is to force the people to accept their status as proletarians and the conditions for the exploitation of the proletariat. It is perfectly obvious that from the end of the Middle Ages up until the 18th century, all the laws against beggars, vagabonds, and the idle, all the police organizations designed to catch them, force them, and this was of course their role, to accept at the particular place where they were the conditions imposed on them, which were extremely bad. If they rejected these conditions, if they went away, if they took to begging or to doing nothing, then it was prison and often forced labor. On the other hand, this penal system was aimed very specifically against the most mobile, the most excitable, the violent elements among the common people, those who were most prepared to turn to direct armed action, including farmers who were forced by debts to leave their land, peasants on the run from tax authorities, workers banished for theft, vagabonds or beggars who refused to clear the ditches, those who lived by plundering the fields, the small-time thieves and the highwaymen, those who, in armed groups, attacked the tax authorities, and, more generally, agents of the state, and finally those who, on days of rioting in the towns or in the villages, carried weapons. There was widespread plotting, a whole network of communications within which individuals could adopt different roles. It was these dangerous people who had to be isolated, in prison, in the Hôpital Général, and the galleys and the colonies, so that they could not act as a spearhead for popular resistance. This fear was great in the 18th century, and it was greater still after the Revolution, and at all the times of commotion during the 19th century. The third role of the penal system: to make the proletariat see the non-proletarianized people as marginal, dangerous, immoral, a menace to society as a whole, the dregs of the population, trash, the mob. For the bourgeoisie, it is a matter of imposing on the proletariat by means of penal legislation, of prisons, but also of newspapers, of literature, certain allegedly universal moral categories which function as an ideological barrier between them and the non-proletarianized people. All the literary, journalistic, medical, sociological, and anthropological rhetoric about criminals, and we are all familiar with examples of all these in the second half of the 19th century and the beginning of the 20th century, play this role. Finally, the distance which the penal system creates and sustains between the proletariat and the non-proletarianized people, all the pressures which are put upon the latter, enable the bourgeoisie to make use of certain of these plebeian elements against the proletariat. They mobilize them as soldiers, policemen, racketeers, and thugs, and use them for the surveillance and repression of the proletariat. It is not only fascism which has provided examples of this. At first sight, these are at least some of the ways in which the penal system operates as an anti-seditious system, as a variety of ways of creating antagonism between the proletarianized and the non-proletarianized people, and thereby introducing a contradiction which is now firmly rooted. This is why the revolution can only take place via the radical elimination of the judicial apparatus, and anything which could reintroduce the penal apparatus, anything which could reintroduce its ideology and enable this ideology to surreptitiously creep back into popular practices, must be banished. This is why the court, an exemplary form of this judicial system, seems to me to be a possible location for the reintroduction of the ideology of the penal system into popular practice. And this is why I think that one should not make use of such a model. Victor, you have surreptitiously forgotten one particular century, the 20th, so I put to you the following question. Is the principal contradiction among the masses that between prisoners and workers? Foucault. Not between prisoners and workers, between the non-proletarianized people and the proletariat. This has been one of the contradictions, one of the important contradictions, which the bourgeoisie has for a long time, and especially since the French Revolution, seen as a means of self-defense. For the bourgeoisie, the main danger against which it had to be protected, that which had to be avoided at all costs, was armed uprising, was the armed people, was the workers taking to the streets in an assault against the government. They thought they could identify in the non-proletarianized people, and those common people who rejected the status of proletarians, or in those who were excluded from it, the spearhead of popular rebellion. They therefore provided themselves with a certain number of methods for distancing the proletarianized from the non-proletarianized people. At the present time, these methods are deficient. They have been or are being taken away from them. These three methods are or were the army, colonization, and prisons. Obviously, the distancing between proletarianized and non-proletarianized people and the prevention of armed uprising were only one of their functions. The army, with the proxy, remplaçant, a call-up system, made it possible to drain off significant numbers, especially from the peasant population, which was over-numerous in the countryside and could not find work in the towns. It was this army which was used against the workers when the need arose. The bourgeoisie tried to maintain an antagonism between the army and the proletariat, and this often worked, though sometimes it failed when the soldiers refused to move or to shoot. Colonization constituted another way of draining off these elements. Those who were sent to the colonies did not take on a proletarian status. They were used as cadres, administrative functionaries, as tools of surveillance and control over the colonized peoples. And it was certainly in order to avoid the forming of an alliance between these lesser whites and the colonized peoples, an alliance which would have been just as dangerous out there as proletarian unity would have been in Europe, that a rigid racialist ideology was foisted on them. Watch out, you'll be living among cannibals. As for the third method of separating off these elements, this was organized around the prison system, and the bourgeoisie erected an ideological barrier around those who went to prison or who had been in prison, an ideology about crime, criminals, theft, the mob, degenerates, animals, which was in part linked with racialism. But look what's happened. No overt form of colonization is possible any longer. The army can't play the same role as it used to. As a result, we have a reinforcement of the police and an overloading of the penal system. These now have to take on by themselves the whole burden of performing all these functions. Systematic police control of every quarter, the police stations, the courts, especially those dealing out summary judgments to those caught in the act, the prisons, the parole and probation systems, the whole system of controls involved in making children wards of court, the social welfare system, reform schools, all these must now perform, here in France, all the roles that used to be taken on by the army and colonization in geographically relocating people and in sending them abroad. The resistance, the Algerian War, May 68, have been crucial episodes in this story, involving the revival and the various struggles of clandestinity, of arms, and of action in the streets. At the same time, there has also been the establishment of an apparatus for fighting internal subversion, an apparatus which has been strengthened, adapted, and refined in response to each of these episodes, but from which, of course, all the corrupt elements have never been purged. An apparatus which has been in continuous operation for 30 years. We can say that the techniques employed up to 1940 relied primarily on the policy of imperialism, the army, the colonies, whereas those employed since then are closer to a fascist model, police, internal surveillance, confinement. Victor, still you haven't answered my question, which was, is the principal contradiction among the people? Foucault, I am not saying that it is the principal contradiction. Victor, you are not asserting that, but the way you tell the story speaks for itself. Uprisings are the result of a fusion between the proletarianized and the non-proletarianized people. You have described for us all the mechanisms which operate to draw a dividing line between the proletarianized and the non-proletarianized people. So obviously, given this dividing line, there are no uprisings, whereas were the fusion to be re-established, then there would be uprisings. Although you say that you don't consider this to be the principal contradiction, it in fact becomes the principal contradiction on your interpretation of history. I'm not going to respond to this in relation to the 20th century. I'll stick to the 19th century and introduce a little extra historical evidence which is somewhat contradictory, taken from a text by Engels on the development of large-scale modern industry. Engels said that the first form of revolt of the modern proletariat against large-scale industry was criminality, that of those workers who killed their bosses. He made no attempt to discover the underlying causes of this criminality, nor the conditions in which it operated, and he did not write a history of the penal system. He was speaking from the point of view of the masses, and not from the point of view of the state apparatuses, and he said that criminality was an initial form of revolt. Then he went on quickly to demonstrate that this was very embryonic and not very effective. The second and superior form was machine breaking, but here again it did not get very far, because as soon as the machines were broken, others immediately took their place. This hit at one aspect of the social order but did not attack the root causes. Where revolt took on a conscious form, it was with the formation of combinations, that is, of unions in the original sense of the word. Combination is the superior form of the revolt of the modern proletariat because it resolves the principal contradiction among the masses, namely the internal contradiction among the masses, which results from the social system and from its core, the capitalist mode of production. It was, Engels tells us, simply the struggle against competition between the workers and thus combination to the extent that this united the workers, which made it possible to transfer competition to the level of competition among the bosses. It is in this context that he situates his early descriptions of union struggles over wages or for the reduction of the working day. This little extra historical evidence suggests to me that the principal contradiction among the masses is the opposition between egoism and collectivism, competition and combination, and that it is when you have combination, that is the victory of collectivism over competition, that you have the working masses, and thus a unity among the proletarianized people, and that then there will be a mass movement. It is only then that the first condition for the possibility of subversion, for revolt, is achieved. The second condition is that these masses gain a hold on all people in revolt throughout the social system and do not confine themselves to the workshops and the factories as the site of revolt, and it is then that you will in fact find them coming together with the non-proletarianized people, and you will also find them joining together with other social classes, with young intellectuals, the self-employed petty bourgeoisie, small tradesmen, and the first revolutions of the 19th century. Foucault. I don't think I said that it was the basic contradiction. I meant that the bourgeoisie saw sedition as being the main danger. This is how the bourgeoisie viewed things, but this does not mean that things will happen in the way that they fear, and that the joining up of the proletariat with the marginal elements of the population will spark off the revolution. All that you have just said in relation to Engels I would by and large agree with. It does in fact seem that at the end of the 18th century and at the beginning of the 19th century, criminality was perceived by the proletarians themselves to be a form of social struggle. By the time that struggles take the form of combinations, criminality no longer has quite this role, or rather, breaking the law, the transitory and individual overturning of power and order which criminality represents, can no longer have the same meaning, nor the same function in struggles. But we should take note of the fact that the bourgeoisie, forced to retreat in the face of these proletarian forms of organization, did everything that it could to divorce this new force from a segment of the population which was thought of as violent, dangerous, without respect for the law, and consequently liable to revolt. Among the methods employed, some were of enormous consequence, as for example, the morality taught in primary schools, that is, the gradual imposition of a whole system of values disguised as the teaching of literacy, reading and writing covering up the imposition of values, and some were rather smaller innovations, tiny and horrible Machiavellianisms. Since unions had no legal status, those in power could use great ingenuity in getting them run by people who one fine day would run off with the funds. It was impossible for the unions to sue them, thus there was a backlash of hatred against thieves, a desire to be protected by the law, etc. Victor. I think that it is necessary to make a point of clarification, to be somewhat more accurate and dialectical in the use of this concept of the non-proletarianized people. The main principal cleavage introduced by the unions, which would turn out to be the cause of their degeneration, was not between the proletarianized people, in the sense of the fully formed established proletariat, and the lumpenproletariat, that is, in the strict sense, the marginalized proletariat, those who had been thrown out of the proletariat. The principal cleavage was between a minority of the workers and the great mass of the workers, that is, the people who were being proletarianized. These latter were workers who were coming from the countryside. They were not hooligans, brigands, street brawlers. Foucault. I think I have never, in anything that I have just said, tried to show that this was a basic contradiction. I have described a certain number of factors and effects, and I have tried to show how they were all interconnected, and how the proletariat was able, up to a certain point, to come to terms with the moral ideology of the bourgeoisie. Victor: You say, this is one factor among others, it is not the principal contradiction. But all your examples, the whole history of these mechanisms as you've described it, tend to put the emphasis on this contradiction. For you, the proletariat first sold out to the devil, and having adopted the moral values, by means of which the bourgeoisie established a divorce between the non-proletarianized people and the proletariat, between the hooligans and the honest workers. I reply, not so. The first selling out to the devil by the workers' organizations was to have made belonging to a trade a condition of membership. It was this which allowed the first unions to become corporations, which excluded the mass of unskilled workers. Foucault: This restriction on membership which you mention was certainly the most fundamental one. But notice what its implications were. If workers who had no trade didn't belong to the unions, this was all the more so for those who were not proletarian. So once again, we can ask, how did the judicial apparatus, and more generally, the penal system, operate? My answer is that it has always operated in such a way as to introduce contradictions among the people. I'm not saying it would be ridiculous to do so, that the penal system introduced the basic contradictions, but I am rejecting the idea that the penal system is a nebulous superstructure. It has played a determining role in the divisions of present-day society. Gilles: I am wondering whether we shouldn't distinguish two different kinds of plebs, or non-proletarianized common people, in this story. Can the plebs really be identified as those who refuse to be workers, with the consequence of this being that the plebs would then have a monopoly on violence, whereas the workers, the proletarians in the strict sense of the word, would be inclined to be non-violent? Isn't this the effect of a bourgeois view of the world, and that it classifies the workers as a group organized within the state, and similarly the peasants, and so on, whereas all the rest would be the plebs, a rebellious residue in this pacified, organized world as the bourgeoisie would have it, in which the judicial system has the mission of controlling the borders. But the plebeians can themselves well be trapped within the bourgeois view of things, that is, they can conceive themselves as being of another world. And I am not sure that being trapped within this view of things, their other world would not be a duplicate of the bourgeois world. Obviously, this wouldn't be completely so, because there are traditions, but it would be so in part. Moreover, there is yet another fact. This bourgeois world, divided but stable, the realm of the familiar judicial system, does not exist. Is there not, behind the opposition between the proletariat and the plebs, who monopolize violence, the coming together of the proletariat and the peasantry? Not the safe peasantry, but the peasantry in potential rebellion. Isn't that which threatens the bourgeoisie, then, rather the coming together of the workers and the peasants? Foucault: I completely agree with you in saying that we must distinguish between the common people as they are seen by the bourgeoisie and the common people as they are in reality. But what we have been trying to see is how the judicial system operates. Penal law was not created by the common people, nor by the peasantry, nor by the proletariat, but entirely by the bourgeoisie as an important tactical weapon in this system of divisions which they wish to introduce. That this tactical weapon was not based on a true assessment of what the actual possibilities of revolution were is a fact, and a fortunate one at that. This is to be expected because the bourgeoisie cannot have an accurate perception of real relations and real processes. And in fact, to speak of the peasantry, we can say that relations between workers and peasants were not at all the target of the Western penal system in the 19th century. The general impression is that the bourgeoisie in the 19th century were relatively confident about the peasants. Gilles: If this is so, then it is possible that the real solution to the problem of the relations between proletariat and plebs is contained in the capacity to resolve the problem of popular unity, that is, the fusion of proletarian methods of struggle and the methods of peasant warfare. Victor: This would not be sufficient to resolve the problem of fusion. There is also the problem of methods suitable for those who are mobile. An army is the only solution to the problem. Gilles. This means that the solution to the opposition between proletariat and non-proletarianized plebs involves an attack on the state, taking over state power. This is also why there is a need for people's courts. Foucault. If what has been said is true, then the struggle against the judicial apparatus is an important struggle. I do not say a basic struggle, but it is as important as was that judicial system and the division which the bourgeoisie created and maintained between the proletariat and the plebs. This judicial apparatus has had specific ideological effects on each of the dominated classes, and there is in particular a proletarian ideology into which certain bourgeois ideas about what is just and what unjust, about theft, property, crime, and criminals have infiltrated. This does not mean that the non-proletarianized plebs has remained unsullied and resolute. On the contrary, for 1.5 centuries, the bourgeoisie offered it the following choices. You can go to prison or join the army. You can go to prison or go to the colonies. You can go to prison or you can join the police. So this non-proletarianized plebs has been racialist when it has been colonialist. It has been nationalist, chauvinist when it has been armed, and it has been fascist when it has become the police force. These ideological effects on the plebs have been uncontestable and profound. The effects on the proletariat are also uncontestable. This system is, in a sense, very subtle and works relatively well, even though the bourgeoisie is blind to the basic relations and real processes. Victor. From the strictly historical discussion, we have learned that the struggle against the penal apparatus constitutes a relative unity, and that everything which you have described as the introduction of contradictions among the people does not represent a major contradiction, but a series of contradictions which have had great importance from the point of view of the bourgeoisie in its struggle against the revolution. But with what you have just said, we are now at the heart of popular justice, which goes far beyond the struggle against the judicial apparatus. Beating up the foreman has nothing to do with the struggle against the judge. Similarly, for the peasant who executes a landowner. This is popular justice, and it is far broader than the struggle against the judicial apparatus. Even if we take the example of the past year, we can see that popular justice was put into practice before the broad struggles against the judicial apparatus, and that it was the former which paved the way. It was the first locking up of the bosses and beating up of their lackeys which mentally prepared people for the big struggle against injustice and against the judicial apparatus, Guillot, the prisons, etc. In the aftermath of May 68, it was really this that happened. Grosso modo, what you're saying is this. The proletariat has an ideology which is a bourgeois ideology and which incorporates the system of bourgeois values, the opposition between the moral and the immoral, the just and the unjust, the honest and the dishonest, etc. Therefore, there results from this a corruption of ideology among the proletarianized people and corruption of ideology among the non-proletarianized people, brought about by all the mechanisms of integration and the various tools of repression of the people. Now, and this is exactly the point, the development of the unifying idea, the raising of the banner of popular justice is the struggle against alienated ideas within the proletariat and elsewhere, hence also among those sons of the proletariat who have been led astray. We must find a way of putting this so as to clarify this struggle against these forms of alienation, this fusion of ideas coming from all the different fractions of the people, a fusion of ideas which enables the divided fractions of the people to be reunited, because it is not with ideas that history is made to move forward, but with a material force, that of the people reunited in the streets. We can take as an example the slogan used by the Communist Party in the early years of the occupation, to justify the looting of shops, particularly those on the Rue Bussy. Housewives, it is right to steal from the thieves. This is perfect. You can see how the fusion works. You have a demolition of the system of bourgeois values, thieves contrasted with honest people. But it is a particular kind of demolition because when you get down to it, there are always thieves. But now we have a new classification. The whole people are united. They are the non-thieves, and it is the class enemies who are the thieves. This is why I have no hesitation in saying, for example, to jail with Reeve Henry. If we look to fundamentals, we see that the revolutionary process is always the fusion of the rebellion of those classes which are constituted as such, with that of classes which are fragmented. But this fusion comes about in a very specific direction. The vagabonds, and there were millions upon millions of them in semi-colonial and semi-feudal China, were the mass basis of the First Red Army. The ideological problems within this army derived precisely from the mercenary ideology of these vagabonds, and Mao, from his red base where he was surrounded, sent appeals to the central committee of the party saying roughly, "Send me just 3 cadres from a factory to counteract a bit the ideology of all my barefoot people." The discipline of the war against the enemy was not enough. It was necessary to counteract mercenary ideology with ideology from the factory. The Red Army, under the leadership of the party, that is the peasant war under the direction of the proletariat, was the crucible which made possible the fusion between the fragmenting peasant classes and the proletariat. Therefore, in order to have modern subversion, that is, a rebellion as the first stage of a continuous revolutionary process, it is necessary for there to be a fusion of rebellious elements from among the non-proletarianized people with the proletarianized people, under the leadership of the factory proletariat and its ideology. There is an intense class struggle between ideas which come from the non-proletarianized people and those which come from the proletariat. The latter must be in command. The looter who joins the Red Army must give up looting. At the beginning he was executed on the spot for stealing a single sewing needle belonging to a peasant. In other words, the fusion only develops with the setting up of rules, of a dictatorship. To return to my very first example, acts of popular justice coming from all the various strata of the people who have been subjected to material and emotional suffering at the hands of class enemies do not develop into a broad movement which advances the cause of the revolution in ideology or in practice unless they are brought under a system of rules. This is why a state apparatus develops, an apparatus which derives from the masses of the people, but which in a certain way becomes detached from them, which is not to say that it becomes cut off from them. And this apparatus in a certain way has the role of arbitrator, not between the masses and the class enemy, but between the warring ideas among the masses, with the aim of resolving the contradictions among the masses, so that the overall battle against the class enemy may be as effective, as focused as possible. Thus, in periods of proletarian revolution, it always comes about that a state apparatus of a revolutionary kind is set up, between the masses and the class enemy, of course always with the possibility that this apparatus might become repressive in relation to the masses. Therefore, there would never be people's courts without these courts being controlled by the people, and hence the possibility of their being challenged by the masses. Foucault. I would like to respond to you on 2 points. You say that it is under the leadership of the proletariat that the non-proletarianized people will join in the revolutionary battle. I entirely agree. But when you say that this happens under the leadership of the ideology of the proletariat, then I want to ask you what you mean by the ideology of the proletariat. Victor, I mean by that the thought of Mao Zedong. Foucault. Fine. But will you grant me that what is thought by the mass of the French proletariat is not the thought of Mao Zedong, and it is not necessarily a revolutionary ideology? Moreover, you say that there must be a revolutionary state apparatus in order to regulate this new unity between the proletariat and the marginalized people. Agreed. But you will also grant me that the forms of state apparatus which we inherit from the bourgeois apparatus cannot in any way serve as a model for the new forms of organization. The court, dragging along with it the ideology of bourgeois justice and those forms of relations between judge and judged, between judge and the parties to the action, between judge and litigant, which typify bourgeois justice, seems to me to have played a very significant role in the domination of the bourgeoisie. When we talk about courts, we're talking about a place where the struggle between the contending forces is willy-nilly suspended, where in every case the decision arrived at is not the outcome of the struggle, but of the intervention of an authority which necessarily stands above and is foreign to the contending forces, an authority which is in a position of neutrality between them, and consequently can and must in every case decide which party to the dispute has justice on its side. The court implies, therefore, that there are categories which are common to the parties present, penal categories such as theft, fraud, moral categories such as honesty and dishonesty, and that the parties to the dispute agree to submit to them. Now, it is all this that the bourgeoisie wants to have believed in relation to justice, to its justice. All these ideas are weapons which the bourgeoisie has put to use in its exercise of power. This is why I find the idea of a people's court difficult to accept, especially if intellectuals must play the roles of prosecutor or judge in it, because it is precisely the intellectuals who have been the intermediaries in the bourgeoisie's spreading and imposing of the ideological themes that I'm talking about. This justice must therefore be the target of the ideological struggle of the proletariat and of the non-proletarianized people. Thus the forms of this justice must be treated with the very greatest suspicion by the new revolutionary state apparatus. There are two forms which must not under any circumstances be adopted by this revolutionary apparatus: bureaucracy and judicial apparatus. Just as there must be no bureaucracy in it, so there must be no court in it. The court is the bureaucracy of the law. If you bureaucratize popular justice, then you give it the form of a court. Victor: then how is it to be regularized? Foucault: I'll reply to that by what is, of course, an evasion. It remains to be discovered. The masses, proletarian and non-proletarian, have suffered too much over the centuries from this judicial system for its old form to be reimposed upon them, even with a new content. They may have struggled since the Middle Ages against this system of justice. After all, the French Revolution was a rebellion against the judiciary. The first thing that it got rid of was the judicial apparatus. The Commune was also profoundly against the judicial system. The masses will discover a way of dealing with the problem of their enemies, of those who individually or collectively have harmed them, methods of retribution which will range from punishment to re-education, without involving the form of the court which, in any case in our society, I don't know about China, is to be avoided. This is why I was against the people's court as a solemn form designed to synthesize, to replace all other forms of struggle against the judicial system. This seemed to me to re-legitimate a form which drags along with it too much of the ideology imposed by the bourgeoisie, with the divisions which result from this between the proletariat and the non-proletarianized people. At the present time it is a dangerous weapon because it will act as a precedent and will be dangerous later on within a revolutionary state apparatus because forms of legal proceedings will be subtly introduced into it which will threaten to re-establish these divisions. Victor: I'm going to reply to you in a provocative way. It is likely that socialism will invent something different from the assembly line. So if someone were to say put Dreyfus on the assembly line, this would be a politically inventive idea because Dreyfus doesn't work on the assembly line, but it would be an invention heavily influenced by the past, the assembly line. The moral is Marx's old idea, the new is born from the old. You say, the masses will discover something, but at the present time there is a practical problem to be solved. I agree that all the forms of the procedures of popular justice would need to be new, that there would no longer be either the bench or the robe. What remains is a regulatory instance. It is this that we call the people's court. Foucault. If you define the people's court as a regulatory instance, I would prefer to say an instance of political elucidation, on the basis of which acts of popular justice can be integrated with the overall political line of the proletariat, then I entirely agree. But I feel some difficulty in calling such an institution a court. I think, just as you do, the acts of justice by which the class enemy is repaid cannot be limited to a kind of thoughtless instant spontaneity unintegrated into an overall struggle. It is necessary to find forms through which this need for retribution, which is in fact real among the masses, can be developed, by discussion, by information. In any case, the court, with its triple division into two disputing parties in the neutral institution, which comes to decisions on the basis of some concept of justice which exists in and for itself, seems to me a particularly disastrous model for the clarification and political development of popular justice. Victor. If a States General were convened tomorrow, where all groups of citizens involved in struggles were to be represented, groups such as action committees, anti-racialism committees, committees for the investigation of the prisons, and so on, in short, all those who happen to be at present representatives of the people in the Marxist sense of the term, would you be against this on the grounds that it invoked an old model? Foucault. The States General have often enough at least functioned as an instrument, not of course of proletarian revolution, but of the bourgeois revolution. But we well know that there were revolutionary processes in the wake of this bourgeois revolution. After the States General of 1357, there was the peasant uprising. After 1789, there was 1793. Consequently, this might be a good model. On the other hand, it seems to me that the bourgeois judicial system has always operated to increase oppositions between the proletariat and the non-proletarianized people. This is the reason that it is a bad instrument, not because it is old. The very form of the court contains the statement to the two parties, before the proceedings, your case is neither just nor unjust. It will only be so on the day when I pronounce it so, because I will have consulted the law or the canons of eternal equity. This is the very essence of the court, and it is in complete contradiction with the point of view of popular justice. Gilles. The court says two things. There is a problem, and then, being a third party, I will make a decision about this problem, etc. The problem is that the power to exercise justice is in the hands of forces which work against popular unity. This is why it is necessary for there to be a representation of this popular unity when it comes to exercise justice. Foucault. Do you mean that popular unity must represent and make manifest that it has, provisionally or definitively, taken possession of the power to judge? Gilles. I mean that the question of the court at Lens was not settled exclusively by the miners and the Ouillère National Coal Board. It was a matter which concerned all the popular classes. Foucault. The necessity that unity be affirmed does not have to take the form of a court. I would even say, though perhaps the analogy is a bit strained, that the court sets up again a kind of division of labor. There are those who judge, or who pretend to judge, with total tranquility without being in any way involved. This reinforces the idea that for judicial proceedings to be just, they must be conducted by someone who can remain quite detached, by an intellectual, an expert in the realm of ideas. When, into the bargain, the people's court is organized or presided over by intellectuals who come along to hear what on the one hand the workers and on the other hand the bosses have got to say, and to pronounce, this one is innocent, that one guilty, then the whole thing is infused with idealism. When it comes to proposing this as a general model of what popular justice should look like, I'm afraid that the worst possible model has been picked. Victor. I would like us to summarize the results of our discussion. The first conclusion is this: an act of popular justice is an action carried out by the masses, a homogeneous fraction of the people, against their immediate enemy identified as such. Foucault. In response to some specific injury. Victor. The full range of present-day acts of popular justice includes all those subversive actions which are at the present time being led by the various strata among the people. Second conclusion. The transition of popular justice to a higher form presupposes the setting up of regulations which aim to resolve the contradictions among the people, to distinguish between authentic cases of justice and cases which are merely settling of accounts, which can be manipulated by the enemy so as to discredit popular justice, to fracture the unity of the masses, thereby to impede the revolutionary movement. Do we agree? Foucault. Not quite when it comes to talking about regulations. I would prefer to say that an act of popular justice cannot achieve its full significance unless it is clarified politically under the supervision of the masses themselves. Victor. Acts of popular justice enable the people to start to seize power when they take place within the context of a coherent overall line, that is, when they are under political command, on condition that this political leadership is not external to the mass movement, and that the popular masses are unified around it. This is what I mean by the setting up of regulations, the setting up of new state apparatuses. Foucault. Imagine that in some factory or other there is a conflict between a worker and one of the bosses, and that this worker suggests to his comrades that some retribution is called for. This would not be a real act of popular justice unless the target and the potential outcome were integrated into the overall political struggle of the workers in that factory. Victor. Yes, but in the first place it must be that the action is a just one. This presupposes that all the workers agree that this boss is a sod. Foucault. This assumes that there will be discussion among the workers and a collective decision before any action is taken. I can't see any embryonic state apparatus here, and yet we've gone from some particular demand for retribution to an act of popular justice. Victor. It's a matter of stages. First there is rebellion, following that there is uprising, and finally revolution. What you are saying is correct for the first stage. Foucault. I had got the impression that you thought that only the existence of a state apparatus could change a desire for retribution into an act of popular justice. Victor. At the second stage. At the first stage of the ideological revolution, I'm in favor of looting. I'm in favor of excesses. The stick must be bent in the other direction, and the world cannot be turned upside down without breaking the eggs. Foucault. Above all, it is essential that the stick be broken. Victor. That comes later. At the beginning you say, put Dreyfus on the assembly line. Later on, you break the assembly line system. At the first stage, there can be an act of retribution against the boss, which is an act of popular justice, even if not everyone in the workshop agrees with it, because there are informers and creeps, and even a small handful of workers who are shocked by the idea. He is the boss, after all, even if things go too far. If he gets 3 months in hospital when he really only deserved 2, it is still an act of popular justice. But when all these actions take the form of a movement of the growth of popular justice, which for me only makes sense with the constitution of a people's army, then you have the setting up of regulations of a revolutionary state apparatus. Foucault. I understand perfectly as far as the stage of armed struggle is concerned, but I'm not so sure that afterwards it will be absolutely necessary for there to be a state judicial apparatus in order for the people to perform acts of justice. The danger is that a state judicial apparatus would take over acts of popular justice. Victor. Let's restrict ourselves to questions which confront us here and now. Let's not talk about people's courts in France during a period of armed struggle, but about the stage we are actually at, that of ideological revolution. One thing that is typical of this is that as a result of rebellions, there is an increase in acts of subversion, of justice, of real alternative power. And these are instances of alternative power in the strict sense, that is, where things are turned upside down, with that profoundly subversive message that it is we who are really powerful, that it is us who are setting things right way up, and that it is the world as it exists at present which is upside down. What I say is that one kind of creation of alternative power among all the others is this: the setting up of people's courts in the place of bourgeois courts. In what context would this be justified? Not for the carrying out of acts of justice within a workshop where there is an immediate confrontation between the masses and the class enemy. As long as the masses are mobilized to struggle against this enemy, then justice can be carried out directly. The boss is judged, but there is no court. There are the two opponents, and things are settled between them, and this involves ideological values. We're in the right, he's Assad. To say he's Assad is to assert a value which, in a way, makes reference to the system of bourgeois values, the hooligans against the honest people, but only in order to subvert it. This is how it would be understood at the level of the masses. In the context of a city, where the masses are heterogeneous and where they must be unified by an idea, for example, the idea of judging the police, where therefore the truth has to be one, where the unity of the people has to be one, there it could be an excellent way of creating alternative power to set up a people's court to challenge the constant collusion between the police and the courts which legitimate their dirty work. Foucault. You are saying that it is a victory to exercise alternative power in opposition to, in the place of, an existing power. When Renault workers grab a foreman and stick him underneath a car and tell him, "You're going to have to tighten the bolts yourself," this is fine. They're actually exercising alternative power. But when it comes to the courts, we must ask two questions. What would it amount to exactly to exercise alternative power over the judicial system? And what is the real power that is exercised in a people's court like that at Lens? The struggle in relation to the judicial system can take various forms. Firstly, it can be played according to its own rules. For example, one can sue the police. This is obviously not an act of popular justice. It is bourgeois justice caught in a trap. Secondly, one can conduct guerrilla operations against the power of the judicial system and prevent it from being exercised. For example, escaping from the police, heckling in the courts, demanding that a judge be made to account for what he's done. These are all anti-judicial operations, but they are still not a counter-justice. A counter-justice would be one that enabled one to put into operation in relation to some person who would, in the normal course of events, get away with what he's done, some kind of judicial proceedings. That is, to seize him, bring him before a court, persuade a judge, who would judge him by reference to certain forms of equity, and who would effectively sentence him to some punishment which the person would be compelled to undergo. In this way, one would precisely be taking the place of the judicial system. In a court like that at Lens, there was no real exercise of alternative judicial power, but primarily of the power to disseminate information. Information which had been withheld from the masses was seized from the bourgeoisie, from the colliery management, from the technical staff. Secondly, the means for distributing information is in the hands of those in power, and the People's Court made it possible to break this monopoly on information. So two important kinds of power were put into effect here: the power of knowledge of the truth and the power to disseminate this knowledge. This is very important, but it is not the same as the power to judge. The ritual form of the court was not in reality a true expression of the powers that were exercised. And now when a kind of power is exercised, the manner in which it is exercised, which must be visible, solemn, symbolic, must only refer us to that kind of power which is exercised in reality, and not to some other kind of power which is not exercised in reality at that particular time. Victor, your example of counter-justice is completely idealist. Foucault, exactly. I think that it is impossible for there to be a counter-justice in the strict sense. The judicial system as it operates as a state apparatus can only have the function of dividing the masses. Therefore, the idea of a proletarian counter-justice is a contradiction. There can be no such thing. Victor. If we consider the court at Lens, in fact, the most important thing was not the seizure of the power of knowledge and its dissemination. It was that the idea, colliery owners, murderers, became a powerful idea, which took the place in people's minds of the idea, the blokes who threw the Molotov cocktails are the guilty ones. I maintain that this power to pronounce an unenforceable sentence is a real power, which has its material expression in an ideological transformation in the minds of those people to whom it is addressed. It is not a judicial power. This goes without saying. It is ridiculous to imagine a counter-justice because there can be no such thing as a counter-judicial power. But there is a counter-tribunal which can operate effectively at the level of the revolution in people's minds. Foucault. I accept that the Lens court expressed one of the forms of anti-judicial struggle. It played an important role. In fact, it took place at the very same time that another trial was going on in which the bourgeoisie was exercising its power to judge, as it really can exercise it. At a single time, it was possible to take word by word, fact by fact, everything that was said at this court in order to expose what was really going on. The court at Lens was the inverse of what was going on in the bourgeois court. What was black in the latter was made to look white by the former. This does seem to me a perfectly appropriate form for getting to know and to familiarize people with what really goes on in the factories on the one hand and in the courts on the other. It is an excellent means of informing people about the way that justice is exercised in relation to the working class. Victor. So we agree on a third point. Conducting a counter-trial, a people's court, in the very specific sense of one that operates as the inverse of the bourgeois court, as what the bourgeois press calls a parody of justice, as the exercise of a counter-power. Foucault. I do not think that the three theses which you have put forward adequately represent the discussion or the points on which we are in agreement. For my part, the idea that I wanted to introduce into the discussion is that the bourgeois judicial state apparatus, of which the visible symbolic form is the court, has the basic function of introducing and augmenting contradictions among the masses, principally between the proletariat and the non-proletarianized people, and that it follows from this that the forms of this judicial system and the ideology which is associated with them must become the target of our present struggle. And moral ideology, for what are our moral values but those which are over and over again associated with and reconfirmed by the decisions of the courts? This moral ideology, just like the forms of justice operated by the bourgeois apparatus, must be submitted to the scrutiny of the most rigorous criticism. Victor. But there can be created a counterpower in relation to morality as well. The real thief is not who you think he is. Foucault. Here the problem becomes very difficult. It is from the point of view of property that there are thieves in stealing. I would like to say in conclusion that re-employing a form like that of the court, with all that is implied in it, the third-party place of the judge, reference to a law or to impartiality, effective sentencing, must also be subjected to very rigorous criticism. And for my part, I cannot see using this form as valid, except in a case where one can, in parallel with a bourgeois trial, conduct an alternative trial which can expose as lies what is taken as truth in the former, and its decisions as an abuse of power. Apart from this situation, I can see thousands of possibilities on the one hand for anti-judicial guerrilla operations, and on the other hand for acts of popular justice. But neither of these involve using the form of the court. Victor. I think we are in agreement about that interpretation of actual practices, but perhaps we have not really got to the bottom of our philosophical differences. 5 February 1972